My name is Elizabeth Main, and I'm a staff attorney with the Eviction Prevention Project at the Georgia Legal Services Program. I'm here today to just talk a little bit about, first of all, some rental assistance programs that are available in Henry County, and then to talk a little bit about the eviction process in Georgia and give some information on that. And lastly, to just briefly talk about a couple of housing scams that we've been seeing in hopes that people will be able to avoid those in future. So again, my organization is the Georgia Legal Services Program. We're a nonprofit. We basically offer free legal services for civil cases, which just means anything that's not criminal. We primarily handle things like education, housing and evictions on the tenant side, and TPOs, child custody issues, and various other civil legal matters. And I will have our information at the end of the presentation, our phone number and our website if anybody needs to reach out to us. All right, so now I'm going to go into courthouse responses to the COVID-19 pandemic. It is still actually an issue. As recently as a couple weeks ago, there was a courthouse in Georgia that closed for about a week because they had to clean the courthouse. There was a big outbreak and a lot of people were sick. So, you know, it is still a problem. Your local courthouse COVID-19 operating guidelines would be posted online. There is a PowerPoint that goes with this presentation, and that website is in that PowerPoint. So if you can, I think it'll be posted online if you can look there as well. In all counties, they're still respecting social distancing guidelines as much as they can. Masks are supposed to be worn. Many courthouses are checking temperatures at the door, so there are some protections in place. Many counties are offering options for remote hearings. This is something that in magistrate court is pretty new as of the pandemic. Not many magistrate courts in Georgia had any options for remote hearings prior to the pandemic. Now a lot of them do, but it's not automatic that you'll get a remote hearing. You must talk to your local clerk of magistrate court to find out how you can request that and if you can request that in your county. Just what to know about remote hearings, since again these are pretty new. We didn't really have these before the pandemic in eviction hearings. Make sure everything is in place for your hearing over 24 hours before the hearing. Don't wait till the last minute to request the hearing be made virtual. A lot of times you'll need to provide proof that, for example, someone is in quarantine because they've been exposed to COVID-19 or someone is sick. You may need to provide that to the clerk ahead of time. So as soon as you find out when your hearing is and that there's going to be a problem, that's when you should request a remote hearing. If you're not using a computer that's set up at the courthouse, and many courthouses do have computers for remote hearings set up there, if you're using your own computer or your own phone, make sure you've checked the video and audio before the time of the hearing. Maybe try to do a video call with someone and make sure they can hear you and see you. Make sure also that, when you're in your hearing, you're not doing other things. You make sure you're sitting in one place with a plain background behind you. Make sure there's not people walking in and out, dogs barking, that sort of thing. Just try to make sure that the judge will be able to see and hear you at all times. Check with your local clerk of court in advance to find out if you need to submit evidence to the court before the hearing and how you should do that. So for example, if you're having an eviction case and there's rent receipts that you need to show the judge, maybe police reports, videos or photos showing the condition of the property, if for example there are repair issues, if there's any written communications between you and your landlord, make sure that the clerk has those if they need to be submitted in advance. Don't wait until the hearing date and try to hold them up to for your phone camera. If the judge can't see them and can't really read them, you're just not going to be able to present those, and that could be very bad for your case. If the clerk of magistrate court wants you to mail in copies of the evidence that you have, don't send the only copy that you have. Sometimes the mail loses things. Sometimes clerks may lose things. That doesn't happen often, but it can. If the only copy that you have is lost in the mail and you don't have it anymore, then you're really going to be out of luck. If you need to, for example, prove that you did pay rent and your landlord says you didn't, you lost your rent receipts. Please be careful about that. And we haven't seen this very often, but if your courthouse is compelling you to attend a remote hearing and you don't have the technology to attend it, or you don't have, the internet connection or whatever to attend it, please contact an attorney. And again, if you are low income, you can reach out to Georgia Legal Services, and we go through our intake process. So now I'm going to go into briefly just some general information about tenancies in Georgia. Tenancies fall under two categories. The first is written tenancies. A written tenancy, essentially, if there's a lease, there's specific rules, guidelines, there's a tenancy term, meaning that, it goes from March 2021 to March 2022, something like that. If there's no written lease, or there's a lease that just says this tenant's going to pay rent each month and doesn't say when the tenancy ends, then this is a tenancy at will. A tenancy at will, there's a specific statute providing what amount of notice needs to be given in order to end that tenancy. The lease would obviously end when the lease date ends. A termination of the tenancy by the landlord, if it's a tenancy at will, requires a 60-day notice. Tenants can terminate a tenancy at will with 30-day notice. If the landlord wants to change the terms of the tenancy, and that can mean requiring you to pay amounts that, now we're going to charge for pest control. We didn't do that before. We're raising your rent. No pets are now going to be not allowed. There needs to be a 60-day notice from the landlord of that. Now, that does mean that the tenant gets some notice, and, again, the tenants only have to give a 30-day notice, so if they need to end their tenancy, they can, give that notice within that time. However, if the 60 days run and the tenant's still in the property, those changes to the tenancy go into effect, even if the tenant doesn't like them or doesn't agree with them. If the landlord gives 60 days notice that the rent is going up by $100, for example, at the end of the 60 days, the tenant's got to either pay the $100 or, the landlord could file for eviction. Both of these tenancies create a landlord-tenant relationship. That means that the landlord has a duty to make repairs in the property and has to use the eviction process to remove the tenant. Essentially, that the landlords are not permitted to just tell a tenant or give notice to a tenant that they need to move out and then put their things on the curb. Landlords must file for an eviction through the courts and obtain an order from a judge saying that they can evict the tenant. There's been a recent issue that's come up a lot during the pandemic with extended stay hotels and whether or not those would qualify as tenancies. Essentially, the conclusion that the courts have come to is that in a lot of cases, if a person is using the extended stay as their primary residence and they can show they're getting mail there, maybe their ID, their driver's license lists that place as the person's home address, if they can show that they're using it as their residence, they have been for a pretty significant period of time, then courts have found that that would be a tenancy. A tenancy at will, which means that the landlord would, this time the extended stay is the landlord would have to give a 60-day notice to end the lease. And if the tenant cannot pay rent to the extended stay, then the extended stay would have to file for eviction, and they cannot just change the locks or set the person's things out. The eviction process. So landlords first have to provide a tenant with a demand for possession. This has to be done before they file an eviction. This is just a legal requirement that's in the statute that says that the landlord has to tell the tenant, you're late on rent, or I gave you a 60-day notice and you're a tenant at will and you didn't move out. I'm demanding possession of the property. You don't have a right to be here anymore. You need to either move out or I'll file for eviction. It needs to be in language that's somewhat similar to that. There's no specific language that needs to be used. It can be done verbally. So if your landlord tells you, I don't want to rent to you anymore, and you just pay rent each month, so you're a tenant at will. Your landlord says, I don't want to rent to you anymore, and 60 days pass, and they say, you need to move out now, verbally over the phone to you or something. That's a demand for possession. It doesn't have to be a formal, legal letter. It doesn't have to be certified mail, anything like that. It can be done orally, can be done in writing, can be done via email or text. Any of these would be enough. Landlords do need to file an eviction affidavit that's sworn before the state or magistrate court to begin the lawsuit. Generally, these take place in magistrate court. However, landlords can file in state court if they choose. The affidavit that the landlord files, and that's what would be served on the tenant, would need to state the reason for the eviction, and if the landlord claims they're owed some amount by the tenant, either because the tenant damaged the property or just owes late rent, the affidavit would need to state what amounts the landlord claims they're owed. If the affidavit doesn't say anything as far as why the landlord wants to evict the tenant, like if the landlord just left it blank, that is not going to be a legally sufficient affidavit, and the landlord would have to file a new one. So just be sure to, if you are served with an affidavit, read it through and make sure you understand what the landlord's claiming. The next thing that happens once the landlord files the document to begin the litigation is service. That document has to be served on the tenant. This can be done one of two ways, either by personal service, meaning that the marshal's office or the sheriff, depending on what your county uses, needs to serve the tenant personally by handing the document to them. Or, and this is specific to eviction cases, there's something called tack and mail service, which means that the sheriffs would tack the eviction notice or post it or tape it, whatever, on the tenant's door. They would attach it to the door and then mail a copy of that to the tenant in person. This is supposed to be used only if the tenant cannot be served in person. So if the sheriff has tried going to their door several times and there's no response, they can post the notice on the door and mail it. When the tenant is served by the notice being posted on the door and mailed, the court cannot enter a money judgment against the tenant unless the tenant files an answer with the court. This is because if they weren't handed the document in person, it limits what the landlord can get from the court unless the tenant files an answer and basically says, yes, I received this notice and I know I'm answering. The tenant can still be evicted, but the court cannot enter a money judgment against the tenant without an answer. All right, so the answer, once the tenant gets served with the document, they have 7 days from the date of service being the date that is on the paper, as the date that the sheriff wrote in that they put that on your door or they handed that to you, 7 days after that date to file an answer with the court. It's not 7 days from the date the tenant found the notice on their door, it's 7 days from the date on the notice. This includes weekends, so it's not 7 business days. If you got served on a Friday, you better file an answer by 7 days after that Friday, including Saturday, Sunday. The information on when and where to file the answer, it would be located on the summons the tenant received. Sometimes you have to read a little bit to find where that is, but it's essentially usually going to be the clerk of court's office at the county where the eviction was filed. The tenant's answer must deny, dispute, or challenge the claims of the landlord. So if you filed an answer saying, my landlord filed this eviction for non-payment of rent, I do owe the money, I'm trying to pay it, that's not really denying, disputing, or challenging the claims of your landlord, so it's not going to be something that will prevent eviction. If you say in your answer that you dispute the amount of rent that your landlord has claimed that you owe, or the amount that they've written in the eviction notice that they say is owed, you don't agree with that, you should write that in there. If you have any other reasons that you think your landlord is not allowed to evict you, like you didn't do what they're saying you did, they say you violated your lease, you say you didn't, you need to write that in your answer. You don't need to write pages, but you need to be specific as to each individual claim and make sure you have a sentence for each reason that you think that the landlord shouldn't be allowed to evict you. Your answer should also contain any claims that you believe you have against the landlord, such as damages for failure to repair. And I'll go into that a little more later on, but your landlord's required to make repairs. If they didn't do that, you need to write that in your answer and say, I believe my landlord owes me money because they didn't repair the property. If you believe they collected too much rent from you and then they just kept it instead of crediting it to your account, write that in your answer. If it's not in your answer, you can't bring it up at court. So if you didn't give the landlord notice that you were going to bring this up at court by writing it in your answer, then the judge is going to say, well, it's not fair that you should be able to bring it up at court and will not allow you to bring that up. So be sure you're careful when you file your answer to put everything in there. Again, generally answers are filed in person at the courthouse. The pandemic, again, caused some changes to the usual procedure there. Some courts, not all, have procedures in place for maybe allowing tenants to file by email or over the phone or electronically. You need to call the clerk of court to find out what these procedures are in your county. There's not one standard procedure for anything but filing in person. Your courthouse may or may not allow you to do this. If an answer is not filed by the 7th day after service, the court will enter a default judgment against the tenant. This can happen and usually does happen as soon as the 8th day after service, meaning the 7th day passes, you didn't file an answer on the 8th day, there can be a judgment against you. The landlord would receive a writ of possession in that case. The writ of possession is the legal term for your landlord can now evict you and can now have the sheriffs evict you, If there was personal service in the case and the tenant didn't file an answer, the order would also include a money judgment. Again, that's why it's important to file an answer. If you don't file an answer, it could be evicted as soon as, the 10th day after you were served or so. If you do file an answer, there would be a hearing set and you would have 7 days after the hearing before you would be evicted. So you do get some extra time by filing an answer. There are only very limited circumstances where you would ever consider not filing an answer. Some defenses to eviction. The first is the tender defense. Georgia Code, there's a Georgia Code, a statute that says that tenants who are served with an eviction affidavit for non-payment of rent only, so not because you broke the lease, not for any other reason, but just for non-payment of rent, if the tenant can pay all the rents that the landlord claims are due, and it has to include the late fees and the cost of filing the eviction case in court, within 7 days of after service, so by their answer deadline, then the tenant has a complete defense to the eviction action. So if your landlord says you owe $500 rent and $62 for the cost of them filing the eviction case, and you can pay them $562 by your answer deadline, you have a complete defense to the eviction. This defense can only be used once in a 12-month period by the tenant. So if it happens if you paid late in July and they filed for eviction, you use the tender defense, it happens again in October, you can no longer use the tender defense. If the landlord accepts the tenant's rent, the tenant still needs to file an answer with the court stating that they made rent. This is a problem that we see often. Don't assume that your landlord is going to, take action to protect you by dismissing their eviction case if you paid the rent. Oftentimes landlords, either they don't do anything or, maybe and in some cases this does happen, maybe they tell you they're going to dismiss the eviction and then they do not do so. You still need to let the court know the situation so that the judge knows that they should not be issuing an eviction order against you. If the landlord refuses your money, so you tried to pay it within the 7 days, but they wouldn't accept it, you still need to file an answer and bring the money with you to court. And ideally, you would have the money in the form of a money order so that is dated within the answer deadline that you had, so within the 7 days after service, to prove to the judge that you did have the money within this time limitation that the statute provides. And if once you bring it to court, file your answer, go to the hearing, the judge should then just dismiss the case and order you to pay the landlord to accept the rent. Another defense, and this is a somewhat recent statutory change, there's now some protection against retaliatory evictions. Now, by retaliatory eviction, there is a specific legal definition for this. It only means that tenants have a right to request repairs and take action to secure repairs from their landlord, and the landlord is not allowed to evict them for doing that. It doesn't mean, my landlord just doesn't like me and they gave me a 60-day notice that I have to leave and I'm a month-to-month tenant. I think that's retaliation. No, it's only in this case of a tenant is requesting repairs and the landlord is trying to evict them because the tenant's trying to get the property repaired. One important thing to note in using this defense is that a tenant is in Georgia cannot withhold rent because their landlord didn't make repairs. In Georgia, there's those two requirements that a tenant pays rent and the landlord has to make repairs. They operate separately from each other. So even if a tenant doesn't pay rent, the landlord still has to make repairs. And even if a landlord doesn't make repairs, the tenant still has to pay rent. So you cannot withhold rent in Georgia for lack of repairs. Some other states do allow you to do this. Georgia does not. And since eviction is a state law matter, whatever the law is in another state does not change your responsibilities in Georgia. If a landlord takes adverse action against a tenant within 3 months of a tenant taking some action to make repairs, it's presumed that the landlord did this in retaliation for the tenant seeking repairs. So if your landlord you asked your landlord to make repairs, and then the next month they raise your rent, and there's no really explanation given for this. They just raised your rent, or they end your lease, or in some way they change the terms of your tenancy in a way that's negative toward you. Within 3 months, then it's presumed to be retaliatory. Tenants must bring this up in their answer if they want to bring it up at court. Again, if you file an answer just saying, I don't owe money to my landlord, but what you really want to do is bring a claim for retaliation, and you don't tell that to the court and your landlord in your answer, you can't bring it up at court then. If a tenant can prove retaliation, it's a defense to the eviction, so your landlord cannot evict you, and the tenant may be entitled to damages. This would be the amount of, by statute, 1 month's rent plus $500. In very, very limited circumstances, a tenant might also be entitled to punitive damages. That's only where the landlord, beyond just doing a retaliatory eviction, in some other way acted, really egregiously badly. If you think that you have punitive damages, it might be good to talk to an attorney to try to figure out, what statute should be used to seek those punitive damages and how much you would be entitled to. That can get very complicated in magistrate court to try to bring those claims. So again, tenants must still pay rent. There are certain circumstances where, if even a situation where the landlord would generally be considered to have acted in a retaliatory manner, if the tenant owes them rent, that's like a defense on the landlord's side to a retaliatory eviction. So if the landlord can prove that the tenant did violate their lease in some way or did fail to pay rent, you are no longer entitled to an eviction protection for retaliatory eviction. This is only available if the tenant's done everything right and the landlord is the only one that has been acting against the law. Okay, so the next step after filing an answer is going to be the hearing. Once you file an answer, the court will set a hearing. Usually that's set fairly quickly after the answer is filed. Sometimes the court can get a little backed up, but generally it's very quickly after the answer deadline. And the hearing itself also moves very quickly. Generally there's a number of cases that are eviction cases that are set for the same time, which is called an eviction calendar. These cases go through one right after another. So it's good to kind of know a little bit about the procedure before you go in so that you're not kind of lost in as everything's moving. The first thing that happens after the judge comes out is she basically calls roll, makes sure everyone is there. Then the judge usually gives a chance for each of the landlords and tenants to talk with each other outside the courtroom to just see if they can settle the case. It's required that you at least try to settle your case, to try to negotiate, a resolution that's satisfactory for everybody. You're not required to settle the case. If your landlord is saying, I want you to move out tomorrow and that's all I'm going to offer you, you don't have to agree to that. You can, if your landlord's attorney is saying that. You can decide that you would rather go back in and have a hearing and talk to the judge. And, the minimum that the judge will usually give is if the judge rules against you, you should still have 7 days to move out. That's kind of the minimum that you can expect from the judge. So if your landlord wants you to agree to less than that, unless there's some benefit to doing so, like, the landlord is willing to waive the rent that you owe or something like that, you don't need to agree to that. If you don't come to a resolution at mediation, you would go back in the courtroom and wait, and the judge will eventually then call your case to be heard. If the court rules for your landlord, again, the minimum they would give you is 7 days to move out. The court generally cannot authorize more than 7 days, even if the court is very sympathetic to your situation and feels, feels terrible that, like, maybe you've had a relative die or someone's in the hospital, or you're having trouble moving because you're disabled or elderly. The court may feel terrible about that, but by law, the judge cannot authorize more than 7 days without your landlord's consent. Even if the judge wants to, they're bound by the law. They can't do that. The judge also cannot order your landlord to agree to a payment plan for the rent without the landlord's consent. Essentially, a lot of cases are strictly non-payment. The tenant just can't pay the rent. The landlord files for eviction. In that situation, if the judge finds that the tenant does owe the rent, they have to give 7 days to move, and they have to issue a judgment against the tenant for the amount of the rent that's owed. The landlords must still go through the sheriff's or police to evict a tenant, even if once they have an eviction order. Before the eviction order, they can't evict them at all. After the eviction order, they must go through the police. In certain circumstances, they can do things like turn off the utilities once they have an eviction order that says they're allowed to do that. But again, that's limited, and the landlord must still go through the police to carry out the eviction order, the writ of possession. Appeals. Either party has 7 days to appeal the court's judgment. This is only if the court issued an order and it was not a settlement agreement between the parties. So if the parties came to some resolution and the tenant put their signature to it, or if in any way the tenant signed saying they agreed to the terms of the order that was issued by the court, that cannot be appealed. If you sign it, you've agreed to it, and you cannot appeal it. So just, again, be very careful about that. Don't sign something just because you're frustrated and you want to leave and you don't want to wait for the judge. Once you've signed it, it's final and you've agreed to it. But if the judge issued an order and you don't agree to it and your signature is not on it, then you have 7 days to appeal the judgment. The writ of possession, again, that's the eviction, you cannot be executed, you can't be evicted until the appeal time expires. If you decide to appeal, if you want to keep possession of the property, so you want to keep living in your home while the appeal is pending, you must pay the amount that the court found is due for past due rent, and you also must pay rent going forward into the court registry. So not to your landlord, but into the court registry. I know that is a financial burden that does often prohibit people from being able to appeal the case. You can still appeal it without paying, but if you're going to do that, you have to move out of the property. If there's a writ of possession, then you would need to move out per that writ of possession, and you could maybe appeal the amount of any money judgment. If the tenant does not win the appeal, then any money that was paid into the court registry goes to the landlord. So just, that is something for tenants to consider when they're filing an appeal, is that there's no guarantee they will get the money that they paid into the court registry back unless they're successful in their appeal. Courts do charge a fee for filing appeals. However, if a tenant is low income and cannot afford to pay that fee, they can request that fee be waived by filing a poverty affidavit. Now, this is a document, it's been around for a while, and the name has changed somewhat, so your court may not call it a poverty affidavit. The old term is a pauper's affidavit. Some people call it an affidavit of indigence. It has various names. Essentially, though, there should be a form that the clerk of court will have that when you fill it out, the judge can make a decision on whether or not they feel that you cannot afford the filing fees. And if you can't, they will waive those fees. They will not waive paying rent into the court registry or paying the past due judgment into the court registry. That is, there's no way to waive that. So that is essentially the eviction process. Again, it's usually a very short process. Between the time that the landlord files for eviction and the tenant is evicted can be less than a month even in some cases. They file, you're served 7 days to answer, next a hearing is set, and then if the tenant is unsuccessful in the hearing, 7 days to move out. So again, very quick process. Next thing I want to talk about, I always want to end with this, is some housing scams that we see that we try to help people avoid. Scams connected to utilities. Utility companies will never call you to ask for payment over the phone. I know with the pandemic, a lot of people fell behind and they're still trying to catch up. We've seen an increase in these kind of scams since the pandemic because of financial issues that people experienced. Again, if someone calls you to be claiming to be your utility company, tell them you will pay online, and then you contact your utility company yourself using contact information that you found on your utility bill or from your utilities company's website. Don't take, never take the number, never go to a website that someone gave you over the phone. Get the information yourself and then call them and find out if that actually was your utility company calling you. Never give your pay information over the phone. Never give any information over the phone. While you're searching for new housing, if you've had to move, and again, this has been something that we've seen a lot, rental housing is very scarce at the moment. It's also extremely expensive. A lot of times that has led to, that's obviously led to a lot more scams being out there, and a lot more people who, in their, desperation to find housing, are willing to maybe accept things from strangers that are maybe a little more sketchy than they would normally do, like accept information or, make payments a little more quickly than they would normally do. Don't provide your personal identifying information or your financial information to someone in order to reserve a property that's being advertised as for rent. Be very careful with these kinds of things because we've had situations where somebody found pictures of a property or took pictures of a property themselves and then made a post online saying that they were renting that property, and then took money from somebody in order to reserve that property. And then the person trying to rent later found out that this person wasn't even the owner of the property. The owner had no idea who they were. And if you don't have a lot of information about the person giving the scam, which they're very unlikely to give you accurate information, we really, like attorneys or law enforcement, have only limited ways to try to recover that money. Especially as an attorney, there's really not much way to file suit against somebody unless you can find them. And it's, if someone's scamming you, they're probably not going to let you find them. So be very careful about paying money to somebody just based on an advertisement that they posted online. Try to make sure you have a good physical address for your landlord before paying them any money. If they take a security deposit and first month's rent from you and then they disappear, you need to be able to let the police or a court know where they are in order to be able to try to recover your money. Be very careful about that. If you can, if you're renting from an individual and not a larger landlord or apartment complex, something like that, it doesn't hurt to try to do a little bit of research to try to find out who actually owns that property and make sure this doesn't seem strange. If it seems strange, follow up and try to verify things before you pay them any money. The last kind of scam is if someone is facing eviction. Evictions are not a criminal matter. They are a civil matter. That means that if someone calls you claiming you're going to be arrested because you didn't pay your rent, or you didn't file an answer on eviction and so you're going to be arrested or anything like that, do not believe them and do not give them any of your financial information. We have had this kind of scam, and again, you will never be arrested for not paying your rent or for being evicted. It's never going to happen. So just please be careful and be very careful about getting calls from people on and who want your information. Last thing, this is Georgia Legal Service Program's contact information for tenant assistance. If you're a low-income tenant, you're having any kind of housing issue, that can be your landlord's not making repairs, they won't accept your rent, they're charging you fees that aren't provided in your lease agreement, whatever. Please call us for information about your rights. Our number is 1-833-457-7529. Again, that's 1-833-457-7529. Our website is www.glsp.org. That's GLSP as in Georgia Legal Services Program.org. You can also apply for help online if that's more convenient. And we're definitely available to assist anyone who's having trouble.